Dear Premier Ford, my name is Hannah Fowler. I'm a Canadian citizen by birth, a resident of Hamilton, Ontario, and an alienated mother of a young teenage daughter. I recently read comments you had made to the media some time ago emphasizing that no public institution, including the courts, should be exempt from accountability. I strongly agree with your statement and would many other parents from Ontario. Your remarks encouraged me to share my experience involving the broken family court system in Ontario and to respectfully offer a couple of common sense recommendations that I believe could strengthen accountability, enhance public confidence, and improve the administration of justice for families in Ontario. I have never harmed or abused my daughter, yet I have been denied any contact with her for the past 2 years of her life as a result of my involvement in Ontario's family court system relating to the father and I separating. In my experience, the family court system has failed to protect my daughter's best interests or to safeguard her right to maintain a healthy relationship with both of her parents. Instead, the family court system has contributed to the loss of that relationship, resulting in profound emotional harm to myself and my family while consuming substantial public resources at the expense of Ontario taxpayers. I share my experience not only because of its impact on my own family, but because I believe it reflects broader systematic issues affecting many families in Ontario and warrants careful review and meaningful reform. The flaws in the system are obvious, but those who operate the system make too much money off the current system and to want to change it. I recognize that every family court case is unique and must be decided on its own facts. However, based on my experience and the experiences shared with me by many other parents, I believe the adversarial nature of Ontario's family court system has, in many cases, been exploited in ways that unnecessarily prolong conflict, consume substantial public funded resources, and undermine the very purpose of the family court system. When prolonged litigation damages or severs a child's relationship with a loving parent and members of their extended family without sufficient justification, the consequences can be profound and long lasting for the child, the family, and the broader community. Many parents who have voiced their stories on social media for many years described similar experiences to my own. I know that my experiences with the family court system are not unique, and I believe these concerns warrant an immediate review and correction. Rather than attempting to recount every injustice that I experienced, I wish to focus on an issue that affects every Ontarian who relies on our justice system, accountability and transparency. When I entered the family court process, I expected the court to hear the evidence, make fair decisions, and issue clear orders to resolve the issues before it. Instead, on many occasions, I was required to attend what was described as case conferences. I was led to believe that the purpose of these conferences was to help the parties peacefully resolve their dispute without the need for a formal hearing, and I supported that objective before I fully understood what was involved. Unfortunately, my experience with these case conferences was very different from what I had led to believe and expected. During one of the earlier conferences, I was intimidated and humiliated. I was subjected to allegations that were false and misleading. I was yelled at by the judge in a manner that was disrespectful and demeaning. I was told that I needed to retain legal counsel, despite not having the financial means to do so. I left the conference feeling afraid of the system and traumatized rather than assisted. These conferences did not move my case any closer to a fair resolution. It has been 2 years now with no resolution in sight, and with me approaching financial ruin. From my perspective, these case conferences wasted valuable judicial and court resources without resolving any of the underlying issues. Instead, I felt pressured into retaining a lawyer that I could not afford to continue participating in the process. Mediation outside of the court system could have done a better job without wasting taxpayer money and court resources. Today, for more than 2 years later, my daughter has had no contact with me, not even by phone. During that time, I have spent thousands of dollars on legal fees, lost my employment because of the emotional and financial toll of the litigation, and watched valuable taxpayer resources continue to be consumed by an ongoing court process. I've also been told that because so much time has passed, a status quo has now been established, making it increasingly unlikely that my relationship with my daughter will ever be restored. The greatest loss, however, is not financial. It is the loss of a mother-child relationship. I fear that my daughter has been deprived of a meaningful relationship with her mother during some of the most important years of her childhood. Former judges, legal professionals, academics, and child development experts have all expressed concerns that prolonged high conflict family litigation can have devastating consequences for children and families. As one former Supreme Court of Canada judge has boldly stated, the family courts in Canada are seriously damaging children and their parents. Their observations and public comments about the system reinforce my belief that meaningful reform is needed to ensure that the justice system protects children while promoting accountability, transparency, and timely decision making. The following are what I believe would be reasonable first step recommendations that the Ontario government should implement to improve accountability and transparency, to save taxpayer dollars, and to make our family court system better than it is today. My first recommendation is that the province of Ontario undertake a comprehensive review of the current case conference process in family court, with the objective of eliminating judicial case conferences and redirecting judicial resources toward timely adjudication. As a Canadian, I entered the court system with the expectation that the courts would hear the issues before them, make decisions based on evidence, and issue clear and enforceable orders to move matters forward. I did not anticipate that much of the process would instead involve repeated case conferences, which I can only describe as private, off the record meetings conducted in the presence of a judge without members of the public present and without an official court transcript being produced. While case conferences are intended to facilitate settlement, they often create the appearance of a formal court proceeding. They are conducted in courtrooms before judges wearing judicial robes, with court staff in attendance, yet they do not result in formal evidence being heard or binding determinations on the substantive issues in dispute. As a result, many litigants perceive these proceedings as a form of court-directed mediation rather than the adjudicative process they expected when seeking access to justice. In my respectful view, this process raises concerns regarding transparency, accountability, and the efficient use of judicial resources. Considerable public funds are devoted to conducting conferences that frequently do not resolve the underlying dispute, while parties continue to wait for an opportunity to have their matters formally heard and decided. Premier, I respectfully submit that eliminating judicial case conferences would allow judges to devote more time to hearing evidence and making decisions, thereby reducing delays, improving public confidence in the justice system, and generating substantial savings for the province of Ontario. Courts should primarily exist to adjudicate disputes and issue timely decisions rather than serving as publicly funded mediation forums under judicial supervision. My second recommendation is that any and all family court related proceedings or meetings conducted involving parties in the presence of a judge or justice of the peace be video recorded, and that copies of those video recordings be made available to the parties involved afterwards. These recordings would not be made available for public distribution or broadcast, but for the sole purpose to provide an accurate record of the proceedings and to supplement the notes taken by the parties. Parties would sign an undertaking not to publish the video recording. Many self-represented litigants are required to rely solely on their handwritten notes to recall what occurred during court proceedings. A video recording would provide an objective and reliable record, reducing misunderstandings, minimizing disputes about what was said or directed by the court, and assisting parties in complying with judicial directions and preparing for subsequent proceedings. In my own experience, I believe that the availability of an objective video record would have promoted a more respectful and professional courtroom environment and prevented the verbal abuse I was subjected to during my case conferences. More broadly, I believe that knowing an accurate video record exists would encourage the highest standards of professionalism and civility among all participants, including judicial officers, counsel, and litigants. A well-known judge from the United States has stated very clearly that court-related proceedings should not be conducted in closed courtrooms. Case conferences in Ontario are in effect closed and secret. Implementing video recording for all proceedings and meetings with parties conducted in the presence of a judicial official would significantly enhance transparency, accountability, and public confidence in Ontario's family justice system. It would also create an objective record of proceedings, reducing disputes over what transpired and potentially decreasing unnecessary motions, appeals, and other litigation. In turn, this could improve the efficiency of the justice system, reduce costs to taxpayers, and enhance access to justice for Ontario families. In addition, video recording court hearings and any meeting where a judicial official is present would also prevent the ability to have transcripts fixed, as has been known to happen. Premier, I respectfully submit these two beneficial recommendations for your consideration. In my view, neither would require legislative amendment. Rather, they would be implemented through policy or administrative direction provided by your government to the Attorney General and the Ministry of Attorney General. By taking these simple and practical steps, your government could make meaningful improvements to the efficiency, transparency, accountability, and public confidence of Ontario's family justice system while delivering better value to Ontario taxpayers. Your public election campaign has often emphasized your commitment to getting the job done. Below is a photo of the front of one of the t-shirts given out at your Ford Fest in Milton, Ontario. Premier, I respectfully submit that the time has come to apply that commitment to strengthening Ontario's family justice system by improving accountability, transparency, by implementing the use of cameras and eliminating the secret, behind closed doors case conferences where parents are being bullied and threatened. Your government has an opportunity to better protect children and families while reducing unnecessary litigation and the significant costs borne by Ontario taxpayers. I hope history will recognize you as the one person with the courage and leadership to undertake meaningful reform of the current broken family court system and leave a stronger, more accountable, and transparent family justice system for future generations. As Supreme Court of Canada Chief Justice once stated very clearly in the public media, the family law system needs to be overhauled. This same message was stated by former Ontario Chief Justice Warren Winkler. Please get the job done, Premier Ford.